The ANC will challenge the registration of uMkhonto Wesizwe as a political party in the Electoral Court in Mangaung tomorrow. The governing party says overturning the IEC's initial decision to reject the application must be upheld. Ziyanda Ngcobo looks at the key arguments.
ANC lawyers are expected to, among others, argue that after initially rejecting the application for uMkhonto Wesizwe to be registered as a political party, the Deputy Electoral Commission CEO had no powers to overturn the decision. The earlier refusal was on the basis that there were some missing documents and didn't fulfill the requirements outlined in Section 15 of the Electoral Commission Act. Despite this, however, the request was granted.
About a month later, in September of 2023, they registered the party, the MK party, based on a supplemented registration. And so the ANC argues that the DCEO was not allowed in terms of the law to do that, and by registering the party, they actually were acting ultra vires, which is beyond the scope of their legal powers.
On the other hand, there's going to be a debate about the jurisdiction of the Electoral Court to hear the matter. Both the IEC and MK party argue that the ANC's legal challenge is premature and makes several procedural missteps because this is only limited to the Deputy CEO's decision and not all members of the Electoral Commission. Added to this, the respondents contend that the governing party initially appealed the use of the uMkhonto Wesizwe name and logo, but never the entity registration as a political party.
The Commission, in fact, dismissed that appeal and said that it's not provided for in terms of the Electoral Commission Act. However, the ANC didn't take that appeal necessarily, that issue, didn't take it to the Electoral Court. They went and took the Deputy CEO's decision to register MK. And the Commission says, no, that was premature. You should have either waited until the Commission confirmed the DCEO's decision, or you should have taken the appeal to the Electoral Court. And so they think that the Electoral Court has no jurisdiction.
There's also an issue around the urgency where the ANC wants to have the registration of uMkhonto Wesizwe declared unlawful and invalid before the May elections.
The point about urgency is raised by both the Electoral Commission and the MK party, but particularly the MK party. The party says that ANC knew by August that the MK party was registered by the IEC, and then later on they did make an appeal with the Electoral Commission in September. However, they waited up until January for them to file a case at the Electoral Court. So they can't claim now that it is urgent when they waited so many months before they took action. So in fact, what MK says is that the ANC seems to have sprung to action when former President Zuma announced in December that he will be campaigning for the MK party.
Benjamin says if the Electoral Court rules in favor of Luthuli House, there may be constitutional implications which will be invited to ponder about.
The constitutional argument that they make is that if the court decides to uphold the ruling in favor of the ANC, then it will deny the members of MK and the voters of MK from exercising their constitutional right to vote and to choose the party they want to vote in terms of Section 19 of the Constitution.
This matter will serve as an acid test of the Electoral Court's fortitude, as this is one of the biggest cases it will deliberate on before the 29th of May polls. Once again, the judiciary finds itself at the center of the country's political system as it now has to decide on the big players in the elections. For Newzroom Afrika on Channel 405, I'm Ziyanda Ngcobo in Johannesburg.